Hi, my name is Amish Agarwal. I'm an advocate practicing in Delhi, and I wanted to talk about giving options to a judge whenever it is possible when you are arguing cases. It's a little difficult to kind of explain this concept in theory, but this example will clear out what I'm trying to convey to you. So recently what happened was, a few weeks before the lockdown, I have this client who was charged with an offense of firing a gun, and we of course disputed the fact that it was an actual gun. It was more of a projectile, but if you look up the Arms Act, there are several nuances in it where air guns, air rifles, even toy guns for that matter, to a good extent are covered if they come under the ambit of the schedule which is there in the Arms Act. Now this particular client as well was facing a very similar issue which a lot of people are nowadays facing. You buy a gun online which is delivered to your house, which the seller or maybe the person who's gifting it to you or the retailer at the market assures you that you don't need a license or anything for this particular thing which shoots pellets or you know, whatever other things that these not guns do. And there were two aspects in this particular case. We were arguing charges. One was the Arms Act. The other aspect was I don't remember the particular section, but I think it was something like criminal intimidation, using a weapon, something like that, or causing disturbance in public, something like that. And we knew that the subsequent section, the causing disturbance aspect, was very easy to tackle because any witness who would come, it would be very easy to cross-examine them and get my client off. But as far as the Arms Act aspect was concerned, because of the technicalities and the harshness of the Arms Act, no matter how much we tried, there was a small possibility that there could still be a finding of conviction, which of course would be unacceptable. So in this particular case, when we approached with an application for discharge, what we did was we asked the judge not to completely discharge the client. I made the submission, and this is not something that you do with a plan. You go into court, you argued everything, and of course my best outcome would be that the matter would be altogether finished off. He would be discharged of all allegations. But when I read the face of the judge, and of course it takes a little time for you to do that, but the bigger lesson that was learnt over here was that when you are there and when you see that the judge might not be inclined to grant you the relief in entirety, rather than the judge himself or herself putting to you to say that in this particular stage this thing that you ask for cannot be granted, you yourself try to give a sort of a concession to the judge so that the judge also does not feel bad about doing what they have to do with your case. So in this particular case, I myself argued that in case the judge is not inclined to quash the matter not quash but discharge, this was before a magistrate. So if I gave of course I am nobody to give an option or a concession to a judge, but the judge has his life a little easier if you yourself point out that maybe if you don't want to give me the entire relief, maybe you can give me a small portion of that relief. And this is precisely what happened. The more onerous, the more difficult to deal with section of Section 25 Arms Act was done away with. Using a point of law that I argued, I did some research, there was something that was in our favor. Just on a purely legal standpoint, we were able to get the client discharged. And now on the aspect of causing disturbance or whatever else that section was that the police has put on my client, I know it will be very, very easy for us to get an acquittal because cross-examination will not be very difficult. The lesson here is, whenever there is a concession, whenever there is a sort of a middle ground that you can come to, even with a judge who apparently has all the power in the world, you still must try to do that. Just very recently, I approached a magistrate for an application under Section 156 Clause 3 of the Criminal Procedure Code. Look it up, which says that if the police are not investigating to a matter, you can direct them to register an FIR and to investigate into the offences. The judge was not really convinced because the scope was very little, because the FIR had already been registered. What I was seeking was monitoring of investigation. And when I could see, even before the judge gave out anything at all, I could see that there was a little bit of an apprehension in the judge's mind. I automatically switched and said, all right, if not in this provision, under the other provision of the CRPC, which is section 91 of the Criminal Procedure Code, there are some things that the police needs to do in this particular case. I am asking you to direct the police to do that. You yourself can do it under section 91, or the police can do it under section 91. All I'm asking for at this moment today is that if not under 156 clause 3, at least give me this relief under section 91, because that is the remedy which is available to you. The judge was convinced, and that is why notice was issued. Having alternate arguments, having concessional grounds ready, the moment you see that the judge is not agreeing, and the trick of advocacy is to be able to preemptively tell when the judge is not going to be inclined to agree to you. And the moment that happens, and hopefully in the future with a little bit of practice, preemptively, if you can give some concession, some middle ground with the judge, that will help out tremendously. In fact, that is what advocacy is. That is what I get paid for. That is what litigators get paid for. The art of advocacy, where you try to, find the thing that will get the relief for the client, even if it is sometimes giving up a little bit of what the client wants.